Namaste and greetings. I, Naina Agarwal, researcher at IMPRI, Impact and Policy Research Institute, Prabhav एवं नीति अनुसंधान संस्थान नई दिल्ली, extend my warmest welcome to you all to IMPRI Web Policy Learning. Today, we are gathered here for the last day of a 3-day immersive online legal awareness and certificate training program on reproductive and conjugal rights of women in India. This training program is organized by the IMPRI Gender Impact Study Center, GISC, New Delhi. I welcome all of you to this enlightening deliberation and thank you for being interested and putting your time, energy, and efforts into understanding emerging issues, considering the impacts of policies in promoting gender equality, women empowerment, and accentuating legal awareness, and thus helping us to bring together the practitioners and participants through this course for impactful policy research and action. This session will be chaired by Professor Vibhuti Patel, Visiting Distinguished Professor, IMPRI. Our convener is Dr. Simi Mehta, CEO and Editorial Director, IMPRI. This 3-day training program has an excellent panel of members who will be sharing knowledge on the above theme. The distinguished panel of members for this program are Professor Dr. Saumya Uma, Advocate Albertina Almeida, Dr. Amar Jaisani, Advocate Dr. Shalu Nigam, Professor Vijay Lakshmi Nanda, Professor Veena Vaswani, Professor Mala Ramanathan, Advocate Audrey D. Mello, Advocate Mrinalini Deshmukh. Before starting today's session, I would like to announce the housekeeping announcement once again. Please join the meeting on time. There will be a Q&A session after each presentation. Share your question on the Q&A box and not on the chat box. The question must not be posted as an anonymous attendee. Ensure that your questions are precise. Refrain from making any general comments in the question to save time. Now, without any further ado, I would like to invite Professor Vibhuti Patel to start the session with her opening remarks and start with our expert session. Looking forward to learning from our esteemed gathering. Ma'am, over to you.
Yeah. Thank you very much, Ms. Naina Agarwal. Good afternoon to all and welcome Professor Saumya Uma, Dr. Advocate Albertina Almeida and Advocate Mrinalini Deshmukh, today's panelists. First of all, let us have a recap of what happened in the previous 2 sessions, previous 2 days. It began with the understanding of reproductive and conjugal rights of women in the overall framework of public health concerns and public health services that was done by Dr. Veena Vaswani. She also examined various global initiatives, UN instruments, and the national provisions, national level provisions, and critically reflected on how public health system has not been able to adequately provide the reproductive rights of women and also ensure conjugal rights of women. She also highlighted the learnings of the pandemic and how the women's miseries got compounded because of the collapse of the public health system and the gender blindness of the public health responses so far as the women's reproductive rights were concerned. The second presentation by Advocate Shalu Nigam focused on the nuances of live-in relationship, what kind of problems the couples in live-in relationship face. She also deconstructed some of the landmark judgments on the living relationships when the parties they were in conflict and the violence took place. She also suggested that okay, laws are there. Laws are even the laws have a patriarchal bias. Some of the landmark judgments are there, but what is most important is that couples whose families, in-laws as well as natal families, if they reject them, they face social isolation. It is very important to create a community support. So the institutional support as well as the community-based supports are very important for the living the persons and the couples in living relationship. This living relationships is not only about the heterosexual relations, man and women, but it can also be among the LGBTQIA community. The third presentation by Dr. Mala Ramanathan was on the public health, the family planning policies and the response of the public health system, how the commercialized private sector responds to women's reproductive needs. And she also compared the Medical Termination of Pregnancy Act in India, which came in 1972, not because of the demands of the women's movement, but with the two reasons. One was a population stabilization, and the second one was of to curtail botched abortion. And there was a lot of India has a very, very high, significantly high maternal mortality and child mortality rate. Abortion-related maternal deaths are also around 17 to 20%. So it is in this context that we got this MTP Act. And what are the revisions made in the 2021 MTP Act? Mainly it's a conflict with the sex-selective abortions and how the medical fraternity has responded. Why in the current situation to get the safe abortion has become such a difficult proposition for women, though legally it is allowed, and even the gestation period is also increased. The last presentation in the first day was about the question of family planning policies and how the society responded to that. And also PCPNDT Act was discussed by Vijaya Lakshmi Nanda. She also located the issue in the overall globalization, neoliberalism, how the multinational pharmaceutical industries, they are functioning, and all of them are hand in glove. So you can't just isolate or penalize a couple who opt for sex-selective abortions. And she tried to connect the issue of sex-selective abortions, which is not only in India, not only in South Asia, but nearly 80 countries in the world have adverse sex ratio. And she also suggested that it is we changing the mindset, though it is a very difficult task, we have to do that with concerted effort. Both the state and non-state actors have to come together. Yesterday's three presentations, I started with my presentation was on reproductive rights of women in India, and I provided the overview of the women's movement's efforts right from 1975 to the present to take up various types of reproductive needs of women, the question of contraception, question of assisted reproduction, question of coercion and repressive methods state is using in a vertically imposed family planning programs, two-child norm, and also what efforts women's movement made through its campaigning, public interest litigation, global discourses, by making the paradigm shift from reproductive control to reproductive rights. Advocate Audrey DeMello's presentation on the law and reality of women and girls facing sexual and domestic violence in India profiled in great detail and the lucid style how the question of sexual and domestic violence was taken up by the women's movement right from the time of anti-rape campaign in 1980. And she also gave the profile of what are the operational dimensions of the series of legal reforms that we have had, and what happens in reality, and how the patriarchal mindset in the criminal legal system, in the community, among the family members, and some of the most heartbreaking episodes or case studies of child sexual abuse, where how the girl gets betrayed by everyone, including her mother. And under what circumstances her organization Majlis has taken up this and provided institutional support to women survivors of violence over last 30 years. Nearly 200 women have been supported. She also critically reflected on the state measures of compensation. She also provided an in-depth analysis of the Manodhairya scheme, which Maharashtra government enacted for providing compensation to the survivor of violence and the inadequacies in implementation. The last presentation yesterday was by Dr. Amar Jesani on role of health workers in assisting survivors of sexual assault. And he said that how the medical fraternity, which with its own patriarchal bias, responds to women survivors of violence. He, being a medical doctor and human rights activist, he also highlighted the kind of problems which the doctors face and the ethical dilemma that they face while providing, doing medical examination, the question of confidentiality, and then the state demanding compulsory reporting, and the girl and her family members not wanting anybody to know about it, and what should a medical person should do in case of they face. He also gave the whole history of two-finger test, which is totally not required. And now, in spite of bringing changes in the methods of medical examination, which are gender responsive, gender sensitive, hardly 10 states are implementing the new methods. They are still sticking to the earlier method, which is traumatizing the victim. Now, today, we have three presentations. All three are focusing on the matrimonial remedy in India. Dr. Saumya Uma's presentation, locating the discourse on restitution, conjugal rights in the debate of Uniform Civil Code and the family laws. In the first day, we had also seen how the religion-based family laws, they in what way they discriminate and promote double standard of sexual morality. So today's second presentation by Advocate Albertina Almeida, and the last presentation of the immersive course is on conjugal rights of women, with special emphasis on property, inheritance, and alimony. Now, currently, we know that there is a universal progress. Reviews have come up, BRIC countries have come together, sexual and reproductive health rights have become center stage in the global discourses, especially in the post-pandemic world. More than 47 countries have alleged their commitment towards universal progress review, and also they have said that the new challenges that we are facing in terms of trafficking of women and girls for sexual purposes, maternal health and maternal mortality in all countries, which has increased, violence against cis women and girls and LGBTQIA has also escalated. Violation of sexual and reproductive human rights of women of LGBTQIA in India and Russia, that with a special focus where in these countries there is a more persecution of LGBTQIA community, early marriages in Africa and Asia, and also harmful traditional practices like virginity test, female genital mutilation in South Africa, and nutrition of women in reproductive age, and incidents of HIV highlighted in the several working groups in the current discussion that is going on between among the BRIC countries like Brazil, China, India, and Russia and South Africa. But at the same time, in G20 also, if you see today's newspapers, in G20 reporting, also the gender issues and the sexual and conjugal rights of women have figured in a different form. So it is in this context, this immersive course becomes extremely important. And today's three deliberations are extremely important. Now over to Professor Saumya Uma.
Unmute.
Thank you, ma'am. Now I would like to invite our first expert for the session, Professor Dr. Saumya Uma. Professor Uma is professor Jindal Global Law School and Director, Center for Women's Rights, JGLS. Ma'am's topic is Restitution of Conjugal Rights as a Matrimonial Remedy in India. Very warm welcome to you, ma'am, and over to you.
Thank you to the organizers, and a special thank you to Professor Vibhuti Patel for actually giving a summary of the last 2 days. Not only does it help the participants in terms of a recap, but it also helps resource persons of today to be able to make a linkage of their presentations with the last 2 days. So thank you very much for that. So as has been, just 1 second, I'm trying to minimize this. Yeah, okay. So as has been announced earlier, my topic is restitution of conjugal rights as a matrimonial remedy in India. This is what I'm hoping to do. I have time till about 3:10, 3:15, when I will. So in that time, this is what I'm hoping to do. I'll start with unpacking the term restitution of conjugal rights. What do we mean by this? It's a very commonly used term in matrimonial law. It is a matrimonial remedy, but I will start with unpacking that. Then we move on to the colonial origins of RCR, the subordinate status of married women, disobedience to the decree of RCR, what was the consequence of that in England. We will then move on to India, and we will trace the history of this remedy in colonial India. Then we will briefly look at the Rukmabai judgment, which is a very landmark judgment on this, discourses around that judgment. Then we will move on to RCR in post-independent India. And then I want to bring in some aspects of how, even though this provision is a gender-neutral provision, how its usage is gendered and how its impact is gendered. So there's a lot of talk nowadays about gender neutrality in the law. So I want to use this particular matrimonial remedy to actually demonstrate how even a gender neutral provision can result in an gendered impact of on women. And then we will look at judicial observations around the RCR, particularly the T. Sarita case and a subsequent judgment, progressive judgment, which was reversed by the Supreme Court subsequently, the current constitutional challenge to the RCR, which is pending before the Supreme Court, and then the conclusion. So I would request the organizers if you can just alert me 5 minutes before I'm to complete my presentation, because when I put the my presentation on full screen, I'm unable to see the clock on my laptop.
You have time up to 3:30.
Okay.
Professor Patel will cooperate.
There are 3 presentations and 3 hours of session. So you up to 3:30.
Up to 3:30, but around 15 minutes for Q&A.
Q&A, yes.
Yeah, which means I must finish my presentation by 3:15.
Yeah.
And
Yeah.
we can go request some time from Albertina ma'am also. But please go ahead.
Yeah.
We can extend the
We
session.
generally like it extends, the session extend till 6. Yesterday also it extended
Okay.
till 6.
No problem.
No problem.
Okay, fine. Thank you.
We have a very
So
interesting.
let's start with unpacking the term restitution of conjugal rights. Now, when when we say restitution, I first want to look at conjugal rights and then move on to restitution. So when we say conjugal rights, rights, rights is linked to entitlement. So what are these entitlements? So one is right to companionship and consortium. Other is right to love and affection. Third is right to stay together, which is cohabitation. And fourth is right to sexual intercourse with the other party to the marriage. These are not exhaustive. There may be other rights, but I'm just kind of indicating to you some of the rights that that come within the package of conjugal rights, right? So, and when we say restitution, what do we mean by restitution? Restitution is about restoring a prior status or a right. And it is the act of, returning something that was taken away or stolen from its owner. So these are some of the, and restitution is also a term that is used in law to compensate for the loss or damage or injury caused. So these are some of the implications of the term restitution. Now, when we use restitution and conjugal rights in the context of a matrimonial relationship, then what is it that we are talking about? So then we are talking about a legal concept and a matrimonial remedy under which a spouse can be directed by the coercive machinery of the law to cohabit with the other spouse in recognition of the right to marital conjugality and consortium of that aggrieved party. But the catch is that this right extends to the aggrieved party, even if the other spouse is unwilling to do so. So if we revisit the bundle of rights that I have put down under conjugal rights, so right to companionship and consortium, right? So one party has the right to companionship and consortium, has the right to love and affection. But can love and affection be compelled? Can anyone be compelled to love? Can anyone be compelled to give affection? And least of all, can the court compel anybody to give love and affection, right? The other right is right to stay together and right to sexual intercourse. Now, with a right, there is a corresponding duty. Now, if the husband has the right, then the wife has a duty to provide sexual intercourse, even if she is unwilling. And if the wife has that right, then the husband has to submit himself, his bodily autonomy towards the woman, even if he is unwilling. So this concept of restitution of conjugal rights, in a way, it keeps talking about companionship and consortium, but it is a camouflaged way of saying that there is a right to unobstructed access to the spouse's body for sexual intercourse against the spouse's will. So we can say companionship, we can say love and affection, we can gloss it over, but at the crux of this entire remedy lies the fact that I may be compelled to submit myself to my partner, marital partner, to my spouse, even if I don't want to, right? So we will, during my presentation, we are going to look at how, although this remains a gender neutral provision, it is not gender equal. There is a gendered use of the provision of the matrimonial remedy, And there is also a gendered impact of this particular matrimonial remedy. So let's look uh, closely at the colonial origins of this remedy, which I'm going to refer to from now on as RCR, that is restitution of conjugal rights. So if we talk about medieval England, in medieval England, marriage could not be dissolved, right? So marriage was considered to be a relationship in eternity, and it could not be dissolved. The only remedy that existed was annulment of marriage, and that annulment provided limited grounds, and it could lead to a remarriage. But what we have through the term annulment is a judicial declaration that there was no valid marriage in the eyes of law. Even today, if we look at the ecclesiastical courts, which are church-based, um, they recognize annulment as a major form, which means that they will declare that no valid marriage existed in the eyes of law. Um, so there was also desertion as a ground for annulment did not exist. So if two people were living together, they got married, they were living together, and if the wife left the husband and she went and started living elsewhere because of whatever reason, it could be because he was violent to her or cruel to her, or maybe because um, she didn't like him and she didn't want to live with him, and she decides to go and to desert him and go and live by herself or to live with someone else, then the only remedy for desertion at that point in time for a spouse was the remedy of restitution of conjugal rights, by which the uh, the spouse who deserted would be brought back, would be compelled to return to the aggrieved spouse. Now, along with the medieval concept and of marriage as indissoluble, and the absence of divorce um, at that point in time, we also have two doctrines. Um, so the first doctrine is doctrine of one flesh. Um, what did this doctrine say? The doctrine said that basically after marriage there is only one flesh. So the woman's flesh merged with the husband. This is a notional concept. So what did it do? It meant that after marriage, um, the woman had a loss of individual identity, autonomy, existence, and basic rights. Okay, so that is doctrine of one flesh. Um, but what this doctrine led to is also called the doctrine of coverture, which is a related concept. And the doctrine of coverture uh, in matrimonial law in England at that point in time, by that um, the legal status and rights of a married woman were subsumed under the husband's protection and authority. So if the woman did not exist as an entity because her flesh was merged with her husband, then this led to a loss of independent legal personality for the woman after marriage. So after marriage, no matter what her husband, if her husband hit her, if her husband mentally tortured her, there was absolutely no legal remedy available to the wife. The wife could not go to the court because the wife was not even considered a legal personality after marriage. Um, so This led to a situation where there was complete impunity for physical, sexual, and psychological violence. And the rights of the married women were determined by the doctrine of coverture. And this extends not only to a situation of, physical or sexual or psychological violence. Married women also did not have an ownership of property. They could not own property. So even property that married women had before marriage, that would, after their marriage, it is the husband who would become the owner of that property. And she could not own property. She could not make any commercial transactions. So married women basically had no real legal personality after marriage, right? So what we see is, on one hand, an absence of divorce on the ground of desertion, plus the doctrines of one flesh, coverture, and the legal remedy of restitution of conjugal rights. When all of this combined together, what we see was an extremely subordinate status of married women. In fact, Sir William Blackstone, in his commentaries on the laws of England, in book one of these commentaries, in 1765, he had written that the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during marriage, or at least incorporated within the husband, under whose wing, protection, and cover she performs everything. So this was the situation at that time, which Sir William Blackstone actually recorded in his commentary. Now, what happened if there was a decree of restitution of conjugal rights which was given by the court, and that particular decree was not obeyed? So let's say if the woman did not agree, even after the court order, if she did not agree to go back to the husband, what happened? So prior to 1813, disobedience of direction to return to the husband for rendering conjugal rights, it led to excommunication. So the woman would actually be excommunicated from the society where she lived in. In 1813, the Ecclesiastical Courts Act replaced this excommunication with imprisonment up to 6 months. Thereafter, in 1884, it removed imprisonment, and it treated disobedience as a statutory desertion, and it entitled the aggrieved person to a judicial separation. Subsequently, disobedience was treated as desertion, and after almost a century, in 1970, restitution of conjugal rights was abolished in England by the Matrimonial Causes and Property Act. So we see this kind of a trajectory in England, where in 1970, this particular remedy was abolished, and it was abolished after there was a commission which recommended its abolition based on the fact that this is not a proper remedy, it is not fair, it is barbaric, and it doesn't really help in, because the preoccupation is with protecting marriages, and it didn't really serve that purpose, and so it was abolished. The irony is that even though in England it was abolished in 1970, in India we continue to have this remedy in the matrimonial statutes in India. Now, let us briefly look at the history of restitution of conjugal rights in colonial India. So, in colonial India, um, uh, if we recall when the British colonialists came to India, one of the things that they wanted to do, or they proclaimed that they were doing, was that they were going to civilize the community. They considered the Indian community to be barbaric, uncivilized, and they considered themselves to be on a civilizing mission, and they were going to civilize the Indian society, even though at that particular point in time, as we saw a little earlier, women in England continue to have a very, very subordinate status, particularly married women had an extremely subordinate socio-legal status. Yet the British colonial rule in India was in a way justified by saying that, oh, we are going to ensure that that Indian society becomes civilized. Um, so in this particular situation, uh, initially the British colonialists said that they will not interfere in the family laws of the practiced by Indians. So it could be Hindu law, Muslim law, Christian law, and so on. They said that they had this policy, or they proclaimed to have this policy of non-interference. But over a period of time, you can see that there are many, many inroads which were made by way of statutory amendments, by way of introducing new statutes. So one of the things that happened at that time was also that the remedy of RCR came to be imposed upon Hindu women for the first time. And this was through the Rukmabai judgment. And I'm going to speak a little bit about it. You can see to your right a photograph of Rukmabai. So Rukmabai was married as a child bride between 1884 and 1888. And she refused to cohabit with her husband. So she never cohabited with her husband, and their marriage was not consummated. What do I mean by the term consummated? Consummation of marriage means that the couple has had sexual intercourse. So this couple, Rukmabai and her husband, did not have sexual intercourse at all because she refused to cohabit with her husband. So her husband filed for restitution of conjugal rights to force her to cohabit with him. He came to know that there was this English remedy, there was this matrimonial remedy which was available in England. So he filed for restitution of conjugal rights in order to force her to cohabit with him, so that he may consummate the marriage, obviously against her will, because she was not interested in living with him, right? So Rukmabai faced a lot of social pressure at that time, and this has been recorded by various articles written at that time. So, but despite the intense social pressure, she declared that she would rather go to prison than forcibly live with her husband. And I have put this link here. You can see the link later. It kind of explains Rukmabai's story in a very simple language and with illustrations and so on. So you can have a look at that. So in this particular case, the case went to was in the Bombay High Court, and you have Justice R.H. Sinhe, who refused to pass the decree of restitution of conjugal rights. And I'm quoting some of his observations in the judgment, made in the judgment. He said it was an outdated medieval Christian remedy under the English law, and it had no foundation in Hindu law. It seems to me that it would be a barbarous, a cruel, a revolting thing to do to compel a young lady under those circumstances to go to a man whom she dislikes so that he may cohabit with her against her will. Since the marriage has not been consummated, there is no legal authority for instituting conjugal rights as opposed to enforcing conjugal rights that has already been instituted. So this was the reasoning that he used, that here, because the couple had not consummated the marriage, or in other words, the couple had not had sexual intercourse, so there was no remedy for bringing her back, for compelling her back to her husband so that he can consummate the marriage. So what the remedy that existed was for restitution of conjugal rights, not for institution of conjugal rights. This is why in the first slide I explained the term restitution. So restitution means he has already had conjugal rights, and then he lost it, and the law then restores it. But what Justice Pinhay said was that he never had it in the first place because there was no sexual intercourse. So there is no remedy available in law to compel the woman to go back to her husband so that he can start having those conjugal rights. And using this reasoning, Justice Pinhay refused to pass the order of restitution of conjugal rights. Now, this happened in 1886. In 1887, on appeal by the husband, the judgment was reversed by Chief Justice Sir Charles Sargent, and he rejected Justice Pinhay's argument of absence of authority, and he emphasized the violation of conjugal duty. He said it was Rukmabai's duty as a dutiful wife. She had to go back to her husband. She cannot, after marriage, she cannot exercise her will to say, I will not stay with my husband. It was her duty to go to her husband. She violated that conjugal duty, and so he issued the decree of restitution of conjugal rights. In 1888-89, there is evidence to show that Rukmabai made an appeal to Queen Victoria. She wrote a letter, and at that time, this particular case was discussed a lot. It became a very, very visible issue both in India as well as in England. And she wrote to Queen Victoria and pleading with Queen Victoria to give her justice. And based on that, Queen Victoria signed a special decree dissolving the marriage and preventing Rukmabai's imprisonment. So this is the story of Rukmabai. Before we move on as to what happened subsequent to Rukmabai, I also want to mention a little bit as to what were the discourses while Rukmabai judgment was going and just after it happened. So you had Hindu nationalists and revivalists who said that Rukmabai's refusal to cohabit was a perfect example of Hinduism and Hindu family being under threat due to English education. So it is because Rukmabai had some kind of an English education that she had this, she was able to assert her rights and exercise her agency. So this was something completely unwarranted, and there was an unwarranted British interference in the sacred realm of a Hindu marriage. So the first argument that I put down here under Hindu nationalists, so it was Bal Gangadhar Tilak who made this observation that um, Rukmabai's refusal to cohabit was, it just shows how Hindu family was under threat because of English education. Then you had Indian social reformers who said that this particular case shows how the barbaric Hindu custom of child marriage, and there was lack of consent in marriage. There's a need for abolition of child marriages, and how important it was to bring in aspects of modernity in relation to women's matrimonial rights. And then you have British colonialists who asserted that British judges have a right to rely on translations of Hindu Muslim religious texts and to interpret it according to English law. And subsequently, through the operation of two particular legal doctrines, that is stare decisis, which means let the decision stand, and the doctrine of precedent, which means we have to follow the decided principle in subsequent cases with similar facts. Through the operation of these two doctrines, restitution of conjugal rights as a matrimonial remedy came to be applied subsequently, and it was applied in both Hindu and Muslim matrimonial cases. So at the time of Rukmabai judgment, prior to Rukmabai judgment and soon thereafter, there were Hindu nationalists and revivalists who were talking in one language, Indian social reformers who took another perspective, British colonialists who took a third perspective. But within all of this discourse, what was lost was the issue of women's sexual agency, bodily autonomy, and her right to personhood. That came to be ignored. So subsequently, restitution of conjugal rights came to be applied in Hindu and Muslim matrimonial cases. And in 1869, this remedy was included when the Indian Divorce Act was enacted. That also had this particular remedy. So in post-independent India, let's look at what happened to this particular matrimonial remedy. So in 1947, India gained independence from the British rule. Indian Constitution, as we all know, talks about right to equality, Article 14, right to non-discrimination on grounds including of sex, Article 15, and right to life with dignity, Article 21. And these are fundamental rights and many other fundamental rights which are guaranteed to everybody, including women, right? Irrespective of the religion that they belong to, and so on. So at this point in time, while we had the Indian Constitution, there were also judgments which looked at Hindu marriage as a sacrament. There was a need to preserve institutions of marriage and family, and this colored their approach to restitution of conjugal rights. So preservation of Hindu joint family, because we had the Hindu joint family. Now, over the last several decades, there's been much more of nuclear family. But at that point in time, in the 1940s, 1950s, Hindu joint family was a much more predominant, and there was a preservation of Hindu joint family that the court felt a necessity to do, and that requires subjugation of women's rights within it. And the matrimonial remedy of RCR came to be used as a tool for this preservation. So in 1955, when the Hindu Marriage Act was passed, it has a section 9 which was included, which talks about restitution of conjugal rights. And it says when either the husband or the wife has, without reasonable excuse, withdrawn from the society of the other, the aggrieved party may apply by petition to the district court for restitution of conjugal rights, and the court, on being satisfied with the truth of the statements made in such petition and that there is no legal ground why the application should not be granted, may decree restitution of conjugal rights accordingly. So this is section 9 of the Hindu Marriage Act. And you will see that without, if the person has withdrawn from the society of the other spouse without reasonable excuse. So suppose there is domestic violence, or if there is sexual violence, or if there is psychological violence, the court may consider that to be reasonable excuse. And if it considers it to be a reasonable excuse, then restitution of conjugal rights may not be ordered. But if the woman has left the man because he was cruel to her, he was physically, sexually, mentally torturing her, then it is up to the woman to go to the court and prove that she had a reasonable excuse, and that's why she withdrew from the society of the other. And then the court will not issue this decree. But the problem, so one other thing with section 9, if we can see, it says either the husband or the wife. So this is a gender neutral provision which is equally applicable to both the spouses. Similar provision came to be in section 22 Special Marriage Act of 1954. We see a similar provision. In 1936, section 36 of the Parsi Marriage and Divorce Act also has a similar provision. And in Indian Divorce Act as well, we have already seen that section 32 and 33 also has a similar provision. And uncodified law that governs Muslims, because on this particular aspect, there is no statute for the Muslims, but through judgment, the matrimonial remedy of RCR came to be applied even to Muslims. Now we see in section 9 and a similar language in section 22 and so on, we see that it is gender neutral legal provision. However, we see that it has had a gendered usage. Why do I say this? Now, though it is available, as a matrimonial remedy, it's available to both spouses, but historically it has been sparingly used by the wife. Why is this so? It's possible that it's because of lower socioeconomic status. There is a social stigma involved in actually even going to the court. Maybe also a lack of awareness of rights, awareness of law, lack of resources, financial resources to actually employ the services of a lawyer who would give the legal advice and give the information that, okay, you can apply for this, you can use RCR as a matrimonial remedy that you can petition from the court. So many women don't know that, right? And even if they knew, because there was a financial dependence on the husband, women more sparingly have been using it historically. It is predominantly used by husbands when the wife tries to escape from a bad or violent marriage. Many husbands also consider it to be an affront to male ego. And in some instances, it has been used by the wife when the husband deserts her for another woman, or when he has neglected her, or when he has failed to give her money for her maintenance. In those situations, even women have been using it. So, in one judgment of the Punjab and Haryana High Court in 1959, um, the court actually observed the motives for husband's petition for restitution of conjugal rights, and it puts down these motives to be three motives. One is for securing the resignation of the wife from her job. Second, this is in situations where the woman leaves the husband and she travels to another city to work. It could be that she was transferred to another city and she goes there to take up her job, and the husband doesn't want her to go to the other city and work there. So then, to secure resignation of the wife from her job, restitution of conjugal rights is used for defeating the maintenance claim of the wife. So if the wife claims maintenance, then the husband would say that, okay, come and live with me and I will take care of your expenses. So in order to defeat the maintenance claim, and thirdly, for preparing the ground for judicial separation or divorce. So if he has no other grounds, then uh, restitution of conjugal rights, once the order is passed, if that order has not been acted upon for a specified period of time, then that itself can become a ground for separation, judicial separation or divorce. So uh, it is the Punjab and Haryana High Court which observed that motives for the husband's petition for restitution of conjugal rights are these three motives. Now, in 1983, we had an Andhra Pradesh High Court judgment in T. Sarita versus T. Venkata Subbaiah, and I'm just going to highlight. So this was a similar case as Rukmabai, where the woman was young and she got married, and then she probably lived with her husband for a little while, and then because of his cruel treatment, she moved away, and he filed a restitution of conjugal rights petition in order to bring her back to him. And in this particular case, Justice Chowdhury of Andhra Pradesh High Court gave a judgment saying that no, the RCR cannot be issued, and he has also made some very, very pertinent observations about the constitutionality of this particular remedy itself. So he has observed in this judgment that by making the remedy of restitution of conjugal rights equally available both to wife and husband, it apparently satisfies the equality test. That means facially it is equal because it is available to both the wife and the husband. But the requirements of equal protection of laws contained in Article 14 of the Constitution are not met with that apparent, though majestic, equality. The question is, how does this remedy work in life terms? So what is the ground legality? So Justice Chowdhury again observes that this matrimonial remedy is found used almost exclusively by the husband and is rarely resorted to by the wife. And the reason for this mainly lies in the fact of the difference between the man and the woman. The life pattern of the wife that is likely to be altered irretrievably, whereas the husband can remain almost as it was before the remedy, because it is the woman who has to beget and bear a child. So this practical but the inevitable consequence of the enforcement of this remedy cripples the wife's future plans of life and prevents her from using that self-destructive remedy. So this is the reason why Justice Chowdhury thinks that this is the reason why she doesn't use this remedy, because it is self-destructive to women. And the judge further observed that a court decree enforcing restitution of conjugal right constitutes the starkest form of government invasion of a personal identity and individual zone of intimate decision. The victim is stripped of its control over the various parts of its body, subjected to the humiliating sexual molestation accompanied by a forcible loss of the precious right to decide when, if at all, her body should be allowed to be used to give birth to another human being. Clearly, the victim loses its autonomy of control over intimacies of personal identity. Above all, the decree of restitution of conjugal right makes the unwilling victim's body a soulless and a joyless vehicle for bringing into existence another human being. So it is a pregnancy that is foisted on her by the state and against her will. And there can therefore be little doubt that such a law violates the right to privacy, right to human dignity guaranteed by Article 21. And Justice Chowdhury also calls the RCR as a savage and barbaric remedy, violating the right to privacy and human dignity. So you can see that the entire focus of Justice Chowdhury's concerns in this particular judgment is what happens to the woman's bodily autonomy. She is being forced, because if the court compels, if the court issues an order of RCR against the woman is compelled to go to her husband. He is going to force himself sexually on her, and this can result in her getting pregnant against her will. So you can see that Justice Chowdhury in 1983 talked about the sexual and reproductive rights of women, of married women, and he did show a concern, and in very clear terms he said that it is a savage and barbaric remedy, and that it cannot be constitutionally a valid remedy, and it is constitutionally void. This was a judgment of Andhra Pradesh High Court in 1983. As we know, a High Court judgment is applicable only to that particular state. So in 1984, we also had a Delhi High Court judgment in Harbinder Kaur versus Harmandir Singh. And in this, the court took a completely different approach, and the court said that the remedy of restitution aims at cohabitation and consortium and not merely at sexual intercourse. To say that restitution decree subjects a person by the long arm of the law to a positive sex act is to take the grossest view of the marriage institution. The restitution decree does not enforce sexual intercourse. The judge in this particular case did not stop at that. He also said that introduction of constitutional law in the home is most inappropriate. It is like introducing a bull in a china shop. It will prove to be a ruthless destroyer of the marriage institution and all that it stands for. In the privacy of the home and the married life, neither Article 21 nor Article 14 have any place. So you can see that one argument that there are two arguments that the Delhi High Court has made in this particular judgment. One is to say that don't think of RCR only in terms of forced sexual intercourse. It is not about enforcing sexual intercourse. It is about conjugality. It is about cohabitation. It is about consortium, right? So, and the judge actually claims that it does not enforce sexual intercourse. The other argument that the judge is making, the court is making in this particular case is a very, very problematic one as well, where the court says that marriage is something which is very, very sacred, and it's a sanctified space, and constitutional rights, fundamental rights like Article 14, 15, 21, they should have no space within the home. The implications of this is that within the four walls, if the husband does anything to the woman, uh, the you know the constitutional rights, the fundamental rights which are guaranteed by the Constitution cannot be used, because the home is such a sacred space. Marriage, the institution of marriage is such a sacred space that Constitution cannot be applied to it. And by that extension, if Constitution itself, if the fundamental rights guaranteed in the Constitution itself cannot be applied, then by extension, no other law, no other statute can also be applied, because the Constitution is the most superior law, right? So all other statutes, statutory laws, legal provisions come after that. But we know that this situation doesn't exist now. We have a Protection of Women from Domestic Violence Act, which actually shows to us that it is the duty of the law and the lawmakers to protect women even within the so-called safe space within the home. And is home a safe space at all is something that the women's movement has questioned again and again. And the women's movements have also questioned that how can you prioritize, preserving and protecting the institution of marriage if it is at the cost of the safety, of the dignity, of the privacy of one of the parties to the marriage, namely the woman. So, because of T. Sarita judgment and Harvinder Court judgment, which were poles apart, and both of them were High Court judgments. So, in 1984, the Supreme Court then said that it agreed with the Delhi High Court judgment in Saroj Rani versus Sudarshan Kumar, and it said that in India it may be borne in mind that conjugal rights, that is the right of the husband or the wife to the society of the other spouse, is not merely the creature of the statute. Such a right is inherent in the institution of marriage itself. So it went one step further and said, even if the statutory provision did not exist, even then, by the fact that they are married, there are certain conjugal rights, and that includes the right of the husband or wife to the society, to the companionship of the other party. So it upheld the constitutionality of the remedy of RCR. Now, what is the current situation? Recently, this is a year ago, there is a petition which has been filed making a constitutional challenge once again to the restitution of conjugal rights. This is in Ojasva Pathak and others versus Union of India and others. It is a petition which has been filed by students of Gujarat National Law University. And there are three major arguments which are made here. One is that the legal framework is facially neutral, but it places a disproportionate burden on women. And so it is violative of women's equality rights under Article 14 and 15. Secondly, it says that the matrimonial remedy of RCR is based on feudal English law that treats women as chattels, and it is steeped in gender stereotypes, and gender stereotypes having gender stereotypes in the law it is also violative of Article 15(1) of the Constitution. Thirdly, it is violative of right to privacy, individual autonomy and dignity of individuals. And here the petition actually draws from a Puttaswamy judgment, which talked about right to privacy as a fundamental right. And it says that because it violates the right to privacy and individual autonomy and dignity of individuals, it is also violative of Article 21 of the Indian Constitution. There is an intervener application which has been filed, which also talks about how this particular remedy is unreasonable, unfair, and unjust. The current status is that it is pending before a three-judge bench of the Supreme Court. So I want to conclude here. I think I've taken a lot of time. So I just want to conclude with this particular slide. So there is a link between restitution of conjugal rights as a matrimonial remedy and non-recognition of marital rape as a criminal offense in Indian Penal Code 1860. As we know, there is a provision of rape in section 375 of the Indian Penal Code, but there is an exception which is given. So husbands are exempted. So so marital rape is not recognized as a criminal offense, even if it is recognized under PWDDA Act, even if it is recognized as a matrimonial remedy, on the ground of cruelty and so on. But as a criminal offense, marital rape is not. There is an exemption that is given for forced sexual intercourse within marriage, right? So what happens is it's precisely because of this non-recognition that the husband can legally compel an unwilling wife to return to him so that he may have sexual intercourse with her against her will and without her consent. And these are exactly the same terminology that is used in section 375, right? Against her will or without her consent. So, but because he is the husband, there is an exemption under criminal law. So he can compel her through this restitution of conjugal rights. So the colonial remedy has really no space in a post-colonial India where the Constitution has promised all women gender equality and a fundamental right to life with dignity, privacy, citizenship rights, and so on, irrespective of their marital status. So whether they are married or unmarried, it should not make a difference. Women still have a right to bodily autonomy, to sexual integrity, and to privacy, whether they are married or not. Yet, it is in the psyche of many, many people, including many judges, that within a marriage, forced sexual intercourse is okay, because at the time when the woman enters into marriage, she gives a blanket consent once and for all for the husband to have sexual intercourse with her. So irrespective of whether she is willing or unwilling, the husband has a right to sexual intercourse. The husband has a right to the personhood of her body. So this is an understanding, and that's why we see that even the marital rape, the petition which challenged the constitutionality of this exception in criminal law, in Delhi High Court, it had a divided. There was a division bench, and one judge said it was unconstitutional. The other judge said it was constitutional. So that too is pending now before the Supreme Court. And I want to end again with emphasizing that although the provision is couched in gender neutral terms, it has had adverse ramifications both for the sexual and reproductive rights and health of the wife. So we see that gender neutral law may not result in gender equality because the society itself continues to be unequal. So even if we have gender neutral terms, there can be a gendered application, there can be a gendered use of that matrimonial remedy, and that remedy can have gendered and very adverse ramifications for one party, namely the wife, and particularly in terms of her sexual and reproductive rights and her health. I will end my presentation here, and I look forward to questions from the participants. Thank you.
Thank you, Professor Uma, for such an insightful session and giving us meaningful information. Now I would like Professor Patel to comment on what Professor Uma said.
I don't have much to comment because she has made such a erudite and logical case in favor of negative aspects and how the restitution of conjugal rights, which has been challenged for last over 100 years by the progressive sections of society, has shown that it violates bodily integrity, dignity, personhood of women. And most important thing which I liked about Saumya's presentation is that how she connects the restitution of conjugal right with violation of women's reproductive rights also. The cases she has given, it is not only film actress Sarita, who was at the peak of her career and was getting all the Padma Shris and all the awards, but that time her husband again discovered her and wanted restitution. Similarly, Sridevi, when she was at the peak of her career, she had also faced this, because earlier when they were struggling, these husbands were nowhere. They did, but when they started earning and they came to limelight, that is the time so you can also see the vested interest and how the restitution of conjugal rights consistently favors the person who is power. And that is mostly, and the patriarchal biases that the constitution had. We had also enacted a women's movement and enacted a play also about the Punjab High Court judgment of a school principal who was transferred after she got the promotion as a headmistress, and the husband successfully he won the case of restitution of conjugal right, and she was forced to give up her career. That the court said that woman's primary duty is to look after her husband, be at his service and children. So those were the days, but that was before the collective opposition by the women's movement came. But I think it made an extremely useful this thing. And current situation where the uniqueness of the Hindu marriage is being shown, it's a sacrosanct, and that's why it is not a contract. And this kind of arguments are also being labeled in the courts, various lower courts and high courts, and even Supreme Courts. So it becomes extremely important to discuss. Thank you, Saumya.
Thank you, Professor Patel. I would like Professor Uma to give us way forward.
Takeaways of your lecture.
I'm sorry, do you want me to say something more?
Way forward, what should the participants with this
knowledge? I think this particular judgment which is there before the Supreme Court is a very, very important one for us to engage with. And I really hope that, you know, the judgment, the petition is decided in favor of using the constitutional principles, and by saying that restitution of conjugal rights as a matrimonial remedy is unconstitutional. That is the way forward. Because if we, that is the way forward from Puttaswamy's judgment, which actually talks about privacy and bodily autonomy and all of that. So if we say that, you know, if the Supreme Court decides that no, it continues to be a constitutional, it is constitutional and it is not an unconstitutional remedy, then we would actually be regressing. We would be going
Yes.
several steps backwards from the Puttaswamy judgment. So I think it is important for all of us to engage and keep observing and follow what the Supreme Court decides in this particular judgment, in this particular petition, which is pending before the Supreme Court.
Yeah.
Thank you.
Because when the Sarita's judgment was this, there was a very strong and robust women's movement to back her, all in Hyderabad High Court as well as all over India. No, so that's very important. Public opinion also shapes, and I think same in the Ratmabai case, the progressive and the social reformers, they stood by her. That's very important to be very active. Yeah.
Thank you, Professor Uma. Now I would like to invite our second expert for today's session, Advocate Dr. Albertina Almeida. Advocate Almeida is lawyer and human rights activist, Goa. Ma'am's topic is locating the discourse on restitution of conjugal rights in debate on Uniform Civil Code. Very warm welcome to you, ma'am, and over to you.
Thank you. And thank you to Dr. Saumya as well, because it has made my task a lot easier, because I can then take it to the next step. I will begin with sharing this presentation. So essentially, the reason I'm talking of locating this discourse in the debate on Uniform Civil Code is because very often the debates over the actual issues that women are facing get lost around, should it be Uniform Civil Code, should it be personal laws, because it says nothing, because these are binary, they are almost like false binaries, in which you don't end up discussing anything about the actual issues. And here you will see, I will show you in terms of the religious texts and or whatever, how there is a strange convergence of all religious as well as the secular law. So you can have an uniformity in discrimination. So therefore we really need to look at what we are talking about when we talk of uniformity, or discuss it in those terms. It's much better to look at the legal provisions. What do they mean in the context of the lived experiences of women? How do women how do women end up facing and experiencing the law, and what therefore needs to be done in the light of their particular experiences of the law is what we really need to talk about. So let me just begin with, yeah, now this I think I don't need to say, because this Dr. Saumya has already
But
talked
in
about.
your working mode, make it in a slideshow mode. No.
Sorry. Yeah.
Fine.
Yes. So here, sorry. Yeah. Suffice it to say that this concept of restitution of conjugal rights is like a it is like a whole basket of items, but like as Dr. Saumya said, the focus is on the sexual intercourse. But really speaking, when one is talking of conjugal rights or it speaks of a lot of aspects, because it's like the reference was made to consortium. The consortium means comfort and company of the other spouse, and includes confidence, enjoyment of association, comfort of dwelling together, intimacies of the domestic relation. The problem is because of the imbalance in generally in the status of women, as a result of which this consortium gets interpreted in a skewed way. And this is what my concern is, because there's also one also needs to respect various viewpoints where one talks of marriage as a consortium. If marriage as either spouse deserving the consortium, this is also a view that I would like to appreciate. But I do recognize that because of the skewed system, we have a situation where consortium is interpreted as strictly as enforcing sexual intercourse, and in a setup where one gender is more dominant than another, it ends up being forced literally marital rape, as Dr. Saumya was pointing out. So what one can see is that this remedy has protected the institution, is trying to protect the institution of marriage, which in turn is about protecting property and bloodlines, and it's about controlling women's sexual behavior and restricting their sexual autonomy. Now, this, as we know, this was something that was applicable in the ecclesiastical courts. These are the Christian religious courts, if I may say, use that expression. So really speaking, the suits for restitution of conjugal rights, just a minute. Yeah, the suits for restitution of conjugal rights were found maintainable even when instituted by persons from non-Christian faiths, so long as there was no reasonable excuse for the court not to grant the right. So what we found is that where it was earlier only in ecclesiastical courts, now they were instituted by persons from non-Christian faiths, because this is a remedy that evolved from the British law. And here was a situation where it was being used here in India by persons of non-Christian faiths. Often it was a means to seek maintenance when the decree was not complied with, as that was the ancillary release. Okay, so here what I mean here is this, that women have used this provision also. Ideally, it should not have been worded the way it is worded, because it does reduce women to chattel. But in the absence of other provisions by which you can have a handle to deal with certain kinds of issues, what women have done is to seek restitution of conjugal rights, and say, because otherwise it is often made out that she left the matrimonial home on her own. So then she sort of seeks that restitution of conjugal rights, and then which he is not willing to, especially in cases where the man has got involved in another relationship. And then when he's not willing to, then she says, okay, then you have left out of your own wish, therefore please give me maintenance. So you find also that this law, as much, although it's not it's phrased in a way that reduces human beings, particularly women, to chattel, although it's phrased that way, as a strategic use, there has been a strategic use by women for sort of arm twisting, in a sense, because what you have to do is, I strongly believe that the law that we have is what shall we say, it is the law is an instrument of the state. So it is designed by the state, and even if we have lobbied, like yesterday you heard Advocate Audrey de Mello say that you have the best laws, you have the domestic violence law, you have the best laws, and yet, I mean, I was also involved in the drafting of the Protection of Women from Domestic Violence Act. But what I found is that at the end of the day, with the best of laws, I don't say we have been able to use that law to leverage rights for women, but still, one would have thought that there was no way now that people that the male spouses or the male member of the family could escape his obligations towards the family. One would have thought with the way the law is, but each time it's a struggle, despite this progressive law, to be able, because of the mindset of the court. So that is what actually happens. So when given that this is how it works, we have to now the challenge before me, I feel, before us as lawyers or as teachers, is to subvert this law to use it for women till such time as we have laws which will be phrased differently. So till then, because that's a process, just now that's the section has been challenged in the That provision has been challenged in the Supreme Court, as Dr. Saumya has said. But till such time, one has to, and there's also the need for certain special provisions, because how does one otherwise, push, and it's very difficult for a woman, for example, to establish that, she didn't leave the matrimonial home out of her own wish. She was compelled to leave the matrimonial home. It's very difficult to establish these things. So it is when she seeks restitution of conjugal rights that she is able to kind of quote unquote prove that she actually wanted to be in the matrimonial home, and she was compelled to leave the matrimonial home because of violence, etc. Especially if it is not very obvious physical violence, which can be proved with medical evidence. Now, so therefore, as long as there is no other corresponding way of establishing, this becomes a tool. This can be a tool in the hands of women, but I agree and completely agree that it should not be worded in this fashion. So, but I just wanted to highlight some different kinds of experiences, just so that we will understand that that there are different ways in which a law gets used. So this is what I wanted to highlight. Yeah, now you would say, like as Dr. Saumya has also again pointed out, as far as the Rukmabai case is concerned, that it was seen as by Bal Gangadhar Tilak. He saw it as an interference with Hindu practices, because she had obtained higher education, etc. And so it became like she's now not following the restitution. As you saw, it's a Christian principle, and which was an import in that sense from the British law, and yet he was talking about interference with Hindu practices. And that is where I will come to how how it became compatible also with Hindu practices. And so you find a patriarchal convergence between the colonialists, and the fundamentalists in each religious what shall we say, in each religious persuasion. So it all originated where law has been seen as a tool for moral hygiene. But now, how? I'm not against morality, but the question is, whose morality, what morality, at whose cost the morality? So, and often we find that even in the context of marriage in early 19th century England, moral hygiene was often infused with religious ideals. Because of the temptation to sexual immorality, that is what now this is the quote that is often used, the biblical quote, which kind of supports the concept of restitution of conjugal rights. So it says, but because of the temptation to sexual immorality, each man should have his own wife, and each woman her own husband. The husband should give to his wife her conjugal rights, and likewise the wife to her husband. And the wife does not have authority over her own body, but the husband has, and likewise the husband does not have authority over his own body, but the wife does. Okay, so now this is the biblical this is the verse in the Bible that is often quoted. Now, if you look at it, I will also come to the feminist interpretation of this. So just to also focus that, first of all, our society is diverse. There are different people with different religious persuasions, and it is not as if even in the religions are a monolith. So how are we going to talk of a uniform civil code? Whose standards, whose yardsticks, whose interpretations of religion or of ways of living are we going to use in the context of a time when dominance of a particular religion or a particular stream of religious persuasion prevails? Now, this in the earlier days, it was located in the Victorian times of the law, and it implied that marriage is indissoluble, because that is again a Christian thing, that a marriage, once what God has put together, man cannot put asunder. So there is this indissolubility of marriage. you have the concept of monogamy, and then you have the connotation of impure bodies was also given to the bodies of women who did not live with their husbands and were consequently imbued with the capacity for sexual deviance. So, you know, if they don't live with their husbands, then they could go, you know, what you call, they could go astray, quote unquote astray, you see. So now what is the feminist biblical interpretation? So they say, see, because if you noticed, it was applicable to both genders. So they say, first of all, there's a mutuality of relationship and authority as to who has rights over whom. And in terms of how those rights are, so that is their interpretation. I'm talking of feminist biblical interpretations. So the payment, so they say that the payment of this debt, by this debt, they mean the marital debt, is something that is given, not demanded. So you cannot demand restitution of conjugal rights. You have to provide conjugal rights as a giving. That is their thing. And this makes all the difference to how this passage, that passage in the Corinthians, has been abused and used and abused. Here, Paul is not speaking of conjugal rights from the viewpoint of the demands of the recipient. Rather, the emphasis is on the responsibility of the giver. The obligation is to give love. This passage does not give someone the right to demand it. So here you see that there is also a different interpretation to the same passage, which becomes the basis, which was the basis for this, which was the basis for this whole concept of restitution of conjugal rights. So this is what I want to emphasize, that you have different religions coming in on the point of restitution of conjugal rights and insisting on restitution of conjugal rights, all coming in from different angles. And then you also have progressive interpretations within those religions. You also have a secular law which talks of restitution of conjugal rights. So it's not also religious versus secular, because the secular law is also talking of restitution of conjugal rights in the same terminology as the personal laws. So therefore the question is it enough if it's a secular law and it's not a religious personal law, or what is it that we are looking at? So here you see, and that's what I say, that strangely the Victorian moral discourse around hygiene converged with upper caste Hindu morality, where certain bodies were othered in the name of impurity. So now here is the take that from the declaration of Manu, that neither by sale nor by desertion is wife released from the husband, was hitherto applied only to women and not men. You see, so there is a compatibility. Strangely, there is a convergence of patriarchy amongst within various religions in terms of interpretations. So therefore, you know, when we talk very often, this discourse around uniform civil code is, you know, let it be applicable to everybody, irrespective of which religion they belong. But what happens is that you have a regressive provision which is applicable across the board to everybody. That is what Goa's that is what you do find in some of the provisions of Goa's law, because I come from Goa, and Goa is seen as one of the models of uniform civil code. I will also tell you what the provisions in Goa are on this point. I will share with you, so that we understand that we should stop looking at whether it's a uniform civil code, whether it's a personal law. Let's look at the provision. Let's look at what are the women's lived experiences of that provision. Now, in the parliamentary debate, because it was compatible with this whole concept of Manu and his concept of Hinduism, it seems like it found acceptability amongst the majority of parliamentarians in the debate on when the discussion was taking place regarding the enactment of the Hindu Marriage Act 1955. And so it went through, and you had this provision of restitution of conjugal rights because it sat very well with the conservative Hindu outlook. But we have to accept that there were progressive voices from amongst the Hindus. For example, there was Mr. Kardekar who opposed the remedy, saying, to say the least, this particular cause is uncouth, barbarous and vulgar, that the government should be abettors in a form of legalized rape is something very shocking. This is what he said regarding the efficacy of this remedy. And yet you have this section 9. I will, since it's already been talked about, I will not go into it, but basically section 9 of the Hindu Marriage Act saying that, you know, if either of them withdraws from the society without any reasonable excuse, then the aggrieved party can file a petition before the district court. And unless a reasonable excuse is given as to why he or she will not join the other spouse, then the court can decree the restitution of conjugal rights. But let me also say that there is also a thing that if the husband, it was not seen as a reasonable excuse. There are judgments which say that if the husband was resorting to Hindu customs of concubinage, it was not a reasonable excuse for the wife to withdraw from conjugal relations. So why I'm raising this is because we are always talking about Muslims, and you know that Muslims, Muslim woman marries one Muslim man marrying 4 wives, etc. But there are also these concepts of customs of concubinage, etc. And these are seen, if the woman refuses to join her husband because of these customs, these have also been seen as a reasonable, not a reasonable excuse for the wife to withdraw from conjugal relations. Okay. Now, as far as Muslim marriage, now the Hindu law, as you know, in Hinduism, marriage is a sacrament. Now, in Muslim law, marriage is a contract. So now the Muslim law by Tyabji is as follows, where it again emphasizes the same thing. Where either the husband or wife has, without lawful grounds, withdrawn from the society of the other, or neglected to perform the obligations imposed by law or by the contract of marriage, the court may decree restitution of conjugal rights, may put either party on terms, securing to the other the enjoyment of his or her rights. So what he's basically saying is that since marriage is a contract, now so as I said, it's coming in from different angles, but the end outcome is the same, and nobody is looking necessarily also at what is the angle from which it is coming, which could also be quite important. So therefore here, what he's saying is, since marriage is a contract, one of the terms of the contract is a consortium, you know, that they must enjoy the company of each other, etc. And they must enjoy the consortium of each other. So therefore, you know, if one of them withdraws from that, then they have to, you know, they have to, what shall we say, they have to make good that thing of, you know, not providing the consortium, because that was the obligation, that was part of the terms of the contract. This is how it has been viewed. Now, let us look at like Islamic injunctions or whatever. So here you have the Holy Quran gives husbands the right to retain their wives with kindness. So here it's worded differently. As I said, you know, in each religious text, it's worded differently. So here it says that the husbands have the right to retain their wives with kindness or part with them with an equal consideration. However, if the husband has not paid the dower money, he cannot ask for the restitution of conjugal rights under Islamic law. So in that sense, it's some sort of a transactional exchange that is taking place here. You don't give me money, I will not, meaning you can't ask for restitution of conjugal rights. So I'm not saying this is the best option, but what I'm saying is that there are some transactional aspects here, because in a court of law, you cannot anyway, even as you have already heard, the remedy of restitution of conjugal rights, unlike other remedies, is not enforceable directly. As in, you cannot catch hold of a person and say, now go, you know, go to bed with the woman, for example. You know, it is not one of those kinds of remedies. So therefore, considering that, now what else can one do when one is compelled? So what are the other transactional aspects that take place is something that we need to look at. Now, the concept of restitution was of conjugal rights again was accepted with strange compromises here in India, in that a woman could not plead another marriage by the husband as a reasonable excuse. So here it was used in this way, like in the Hindu setup, it was used as that if the husband is having a concubine as per customs, then that's not a reasonable excuse, was how it was used at then. And this in terms of Islam, sorry, in terms of, sorry, I think I've gone back. In terms of the Muslim law, it is that, if he has married another woman, who is entitled to, he's still entitled to restitution of conjugal rights, because that's an accepted concept, and part of the contract of marriage is about conjugal rights. So then, but again, here also there have been there have been opinions by feminist Muslims who say that such a concept is un-Islamic, because in reference to Islam, in Iranian civil code, I came across this, that they said it's un-Islamic to provide unequal conjugal rights to husbands, as the Quran makes no distinction on the basis of gender. So you cannot provide unequal conjugal rights to husbands. That is what, that is how it was. It is how, it's also a question of a different way of interpreting it. Now let's come to the secular law, because we've talked about religious laws, and as Dr. Uma has already pointed out, there's also the Parsi law, etc. So you have other laws also which have these provisions. Now so we've talked about religious laws. Now, is the secular law any different? Here you have the same provision, where either the husband or the wife has, without reasonable excuse, withdrawn from the society of the other, the aggrieved person may apply by petition to the district court for restitution of conjugal rights. So it is like, it is that reasonable excuse in a society from whom, in a society where women are still, where there is a patriarchal perspective, that word reasonable excuse will always be interpreted by judges who are also from that same society in the same manner. You have exceptions, I do not say, but by and large, this is what is going to happen. And it's always a challenge to kind of discuss and interpret and pose what it means, that what is reasonable excuse. And to say, for example, that if he is verbally abusing, you are met with responses like, but that is part of marriage. There are always arguments in a marriage, as if mental abuse or verbal emotional abuse is just arguments which are part of a marriage. So it is always a challenge that with these kinds of words. And like Dr. Uma pointed out, this gender neutral law is not necessarily gender neutral, because it's having an equal law among unequals. So what I wanted to say in that whole process was that it's not only religious laws which are problematic, it's also the so-called secular laws which are problematic, because they have similar provisions. So let us stop looking at laws in terms of this religion, this personal law says this or whatever, because the secular laws are as problematic. So we really need to look at the provisions, and what is, I would, at the cost of repetition, I would say, and what is the implication of these provisions for people, for the various stakeholders in the family law. Are they provisions that are democratic? Are they provisions that are just and equal in the real sense of the term? Is what we need to look at, irrespective of the label, whether it's called Special Marriage Act, Hindu Marriage Act, Shariat Act, Muslim Law by Tyabji, Parsi Act, whatever it is called. So the Supreme Court, as you know, again, the Supreme Court is also not a monolith. So you have different kinds of provisions, decisions that have come from the Supreme Court. So you have, just like the religious doctrines also are not like the religion is not a monolith. There are different kinds of sections within the various religious groups, and also different interpretations within the same sections also. So the same thing happens in the Supreme Court, which is supposed to be the secular court, So here in Saroj Rani versus Sudarshan Chadha, of course, the Supreme Court held that was not a legal transplant, as she said, or a creature of statute, but it's a very right inherent in the very idea of marriage. The court went further to argue that the remedy for restitution was aimed at ensuring cohabitation and consortium rather than sexual intercourse. This is what it said. Now, in this most recent judgment, which was pronounced this year, Joseph Shine versus Union of India, the Supreme Court held that marriage does not result in ceding the autonomy of one spouse to another. So you have a different kind of interpretation of understanding of worldview of what should marriage be and what marriage should not be. So so what I want to say is, therefore, we should be careful when we flaunt the word uniform civil code, or when we assume that uniform civil code would mean that everything would just clear up, and women would reach the sky, so to say. It would hold up half the sky, so to say. Yeah, like Dr. Uma said, these are superficially gender neutral. Men use this provision subversely to derail a woman's application for maintenance. Also, incidentally, I have found it from my experience, they use it also to derail her application for custody of the child. Then the location of the matrimonial home is that decided by the male spouse. So you have an unequal situation where you have this judgment, as was pointed out, where the male spouse's location decides he decides what's the matrimonial home. So if she's transferred, he has a right to say, oh, you come back, this is the matrimonial home. So therefore the provision is a kind of, this provision for restitution of unequal rights is a kind of, though it's available to both, it's equal among unequal, it's a kind of equal among unequals position. Okay, now let us come to Goa. Okay, so now Goa has, for those of you who may not know, Goa does not have Hindu personal law, Muslim personal law, Parsi law, whatever, or Special Marriage Act or anything. We have our own set of laws. Now, most of them are equally applicable across religions. Do we also have a chapter called Customs and Usages of Gentile Hindus, as they call them. So there are some exceptions made for the people from who, though the word Gentile Hindus is used, it means all non-Christians. So that is the implication of that word in the course of the law. But what I want to say is, to the extent that they are uniform. Now let us look. These are uniform provisions. When the wife abandons the husband, Article 1470 of the Portuguese Civil Procedure Code, that is still applicable to Goa. When the wife abandons the husband or refuses to accompany him, being bound to do so, he may apply that the wife be restored to him through the court. The restoration shall be applied by the court where the wife is found. In the court where the wife is found. There are exceptions. The exceptions are, now this is a provision which is a sort of a mixed kind of plus and minus provision. This exception is, a married woman may apply for judicial custody. Now see the expression that's used, just like in the previous, just like in the law on restitution of custody, conjugal rights. It's in some ways it's a leverage for the woman, this provision, but it's like she's applying for judicial custody as an act in preparation for a suit for divorce or separation of persons and properties, and also during the pendency of such proceedings, either as a plaintiff or as a defendant. So she's not her own person. So she can't be, what she's doing, she can do is say that I have this problem, I cannot live with my husband. But since I would be considered as an errant woman if I don't live with my husband and live elsewhere. So I have to legitimately be living elsewhere. So I have to apply for judicial custody to be awarded to an honest family of the choice of the judge, preference being given to the relatives of the wife. And she may take with her her clothes and objects of her use. So you see, all these provisions are problematically worded. Now here is an uniform provision applicable across religions. So do you see that the whole concept of uniform civil code means nothing, because you see this provisions uniformly applicable, and we can see that how these get used in the end. So we have to look at this whole thing of, look at it across geographies and legal histories as well. Now, restitution of conjugal rights flags the whole thing of, violation of the right to privacy. But what will you say to a woman who, here I'm just only trying to point out that, to contextualize and to speak of the intersectionality and, to ask whose norms, to get back to my point about whose norms are you going to talk about when you're talking of laws for a community. Here itself, within one community, you have so much, so much of difference within communities. And here, when you're talking of so many different religious persuasions, different ways of worldviews, how are we going to talk about uniform civil code? Whose norms will prevail? It will be the norms of the politically dominant party, the politically dominant community from to which the reforms or whatever quote unquote reforms will have to yield. So now here you see, what will you say to a woman who never ever had privacy in the first instance because of the limited size of her dwelling house, which is, if she lives in a say a 6x6 room with a joint family, and that's the only room, where does she have privacy anyway? So what are we talking about? So how should we phrase this whole phrase our opposition is also something I feel that we should raise, because if we talk in terms of rights to privacy, then we have to be very clear in spelling out in what form we are talking of this right to privacy. Now we talked of Rukmabai's case. Rukmabai came from the marginalized Sutar carpenter caste, where community customs allowed for widow remarriage and perhaps a woman's right to dissolve her marriage. Her own mother had remarried after the death of her husband. So here is not a question of English education. Here is a question of a community. So, but yet it is so easy to use those familiar red flags or familiar flags and sort of wave those flags when you don't want something which is not convenient, which upsets the status quo. Then you conveniently say convent education, English education, or whatever. But the point is that this is a concept in any case which was introduced in India from the English law, and yet they want to uphold that provision. So we see how there is a patriarchal convergence, and that is what legal scholar Usha Ramanathan talks about. In her study of cases between 1920 to 1950, she finds that the standard of reasonableness, so what is reasonable? Whose standards will we take? So it says, although taking on a mask of principle is largely a sweeping generalization that displaces difference and produces stereotypes about women. So it's about a sweeping generalization which is called reasonable, and it is by the yardsticks of as one can see, as far as India's laws are concerned, by and large, it is by the yardsticks of the upper caste Hindu male. That seems to be the yardstick whenever the discussions are taking place, have been taking place, now even more so. So therefore, I would like to leave you with these questions in the context of the whole debate on Uniform Civil Code. Whose norms will prevail in the Uniform Civil Code? Is each religion a monolith? Within the religions, whose interpretations of scriptures, whose practices will prevail? Is the secular, again, if you're talking of secular, is the secular always just? We talked of Special Marriage Act, which also has the provision. That's a secular law. Is it just? And then does mere equality suffice? Should not we be looking at substantive equality? The whole question of gender neutrality, equality. So, a woman has a right to restitution of conjugal rights. The man also has a right to restitution of conjugal rights, the husband. So both have. So it is equal. But we know that the conditions of men and women are different. So yes, they have. Yes, I as a lawyer have used this provision for women to kind of subvert the law in some ways. Yes, I have. But I'm saying the point is, it is so much more difficult for her to use this provision, which is seemingly equal. So is it enough to have equal provisions? Do we need to have equal so-called equal provisions means for you also, or do we need to have substantively equal provisions which take into account the context and the fact that the people in the various stakeholders in the family law are not on the same footing? These are the questions I would like to leave you with.
Thank you, Advocate Almeida, for such an enriching session and essential information. Now, I would like Professor Patel to comment on what Advocate Almeida said.
Yeah. Albertina, you made an excellent contribution with so many important comparative between different religious personal laws, whether it's Islam, Hinduism, which calls itself marriage is the union of souls and secular, while in Islam it is a contract. But still, after your very, very erudite presentation, I would like that why should we use RCR when we have Protection of Women from Domestic Violence Act? Because the same clauses, the way domestic violence is defined, emotional, psychological, physical, sexual, and economic violence. Why can't we use this for the remedy? Number one. Number two, when you talk about the second one is that what next? That also you should say, because when restitution of conjugal rights is not respected by either of the parties, no, because educated women, if you see recently the divorce is initiated by women, they are economically independent and educated. Now, in such cases, what next? What is the legal remedy? That I would want you to clarify. And one thing which I like very much, the treating the parties, both the parties equally when they are in unequal socio-cultural context, I think that is unjust. So that is extremely true. And that's why I think we want equity, not only in the legal field, but everywhere in all aspects of society and all sectors of economy. Yeah. So these two questions.
Sorry, I missed the second, but I'll come to that. First question I'll respond to first. That is, why is restitution of conjugal rights still used in the face of Domestic Violence Act? Now, the Domestic Violence Act does not provide for the relief of divorce or separation or annulment. It does not provide for these reliefs. The Domestic Violence Act is about interim reliefs relating to problems of domestic violence, which of course encompasses now physical, verbal, emotional, sexual, economic violence, abuse, no doubt, but it is only providing for it does not provide for the relief of divorce. Now, as far as restitution of conjugal rights, it is seen as the what you call the step to then seeking a divorce. So if you seek the restitution, we all know the restitution of conjugal rights cannot be enforced, but a woman can explain when a petition is filed against her that she's wanting a divorce, or she can also use it to say that he has no reason to seek a divorce, because we also have to look at the social factors. The social factors are that a woman who is got Saubhagyavati in before her name, she values that Saubhagyavati thing status. So she wants to even whether she's staying in with him or not, or whether she wants to stay with him or not, more than anything else, she values that Saubhagyavati status, for example. So now, if she is, because her conditions in an alternative to the Saubhagyavati status are not the best. It is not as if she is out of that, it is not as if she's got a divorce, she's out of problems, because there is so much stigma attached to a woman who is divorced. She might be struggling in terms of survival because, the maintenance may not take care of it, because it's not the same as living in the same household. Now, if they're living in a separate household, for example, so then there is rent to pay, etc., which would not be taken care of really adequately in terms of maintenance, etc. So there are all these issues, and not necessarily you get a rental place when you go somewhere, that you get a rental place if you're a divorced woman, especially, or a single woman, because because you see, the restitution of conjugal rights is the whole thing about, one woman to a woman to a man, and so she can't get sexually deviant. Whereas this single woman, or the woman who is divorced or separated from her husband, will be seen as somebody who who can be sexually deviant. So for example, if there is a bungalow and they have a like a side room, what do you call, unit,
Outhouse.
yeah, outhouse, or they have like a accommodation which many couples do as a pension kind of for themselves. So here they may not give that to the single woman. There will be the thing that she might lure the man of the house or something like that. So there are all these issues. So women do not want to be divorced. So now in this case, what she would do, like for example, I have done is where her husband has filed for divorce and she doesn't want a divorce because it's of no use to her. That tag of divorce is a problem. So then she sort of defends herself saying, I am, it's a counter suit for restitution of conjugal rights in one way. The other way is where she's talking of restitution of conjugal rights is also a step to, once she does that, she can file, once she has done that and he has not complied, or as we said, we cannot, it's one of those rights which cannot be enforced strictly, but non-compliance can mean that then becomes the evidence for seeking a divorce or separation, saying that he has not performed his obligation. So what I mean is, I agree it's badly worded. It treats women as chattel, but in the absence of a provision that would, and I would say not a provision, rather the whole evidence raising, evidence collection mechanisms, which have got to do with the outlooks of the court, really, where as I said, if she's if she talks about how he used to say this or that to her, then the court will dismiss it as say, oh, that's all arguments in the nature of marriage, which are part of a marriage. So therefore, now in that situation, you need something to kind of, in some ways, it helps to cling to this. So what I'm trying to say is, I don't have a solution, because at the end of the day, we are not, the law is the instrument of the state. So, but what I'm saying is that if we keep flagging this, then at least we open up in terms of evidence, how evidence is appreciated in the courts, so that we will, and we keep pushing the boundaries. And that is how we have to do it, because we have to keep pushing the boundaries of the law and keeping on subverting the law to the advantage of the marginalized stakeholders in the family. So that was the first question. The second question was,
what next? If you see, in case of Sarita, she got justice, but in case where the court says that you have to abide by restitution of conjugal right and the party doesn't want, then what next?
Okay, so now here is where I know that's the,
happening
so I
with a lot of educated career women in this days. It is happening.
Yes.
Yeah.
So the thing is that in Rukmabai's case itself, what she did was she paid a compensation. It's not only also that the queen allowed it, but she allowed it on terms that she pays compensation. So she paid, I think, what was 2,000 rupees, if I remember right, in those days, Saumya, I think so.
Yeah. But now in current situation,
so the point is that I agree that restitution of conjugal rights is not is a provision that should not be there, but I think that there has to be some other provision which becomes a handle, because basically restitution of conjugal rights is a handle for something else. Because if she doesn't obey, now there is no what shall we say, penalty. There is attachment of property, which I think the next speaker will speak about. So I've not touched on it much. So the point is,
but what about irretrievable breakdown of marriage? Can't she use that as a clause?
Yeah, no, irretrievable breakdown of marriage is not a ground for divorce. So yes, it is not a ground for divorce yet. Yes, but I'm not sure. So there has been this argument within the women's movement, that this discussion, that if you use that irretrievable breakdown of marriage in a context where rights are not where rights are not properly crystallized in terms of marital property rights, what it will mean is that a man who wants an out from his obligations towards marriage will simply flash that irretrievable breakdown of marriage and walk out of it, without complying with his obligations.
But that's
So
what
then-
the NRI husbands are doing, no? In the courts in America and in England and Europe and this. So they say irretrievable breakdown of marriage and ex-party divorce they are getting, no?
Yes, so that is problematic. That is why, I mean, ideally one would have said, yes, you know, why should people be forced to live in a relationship? But I think that there is in a marital relationship, I would say that I'm not a proponent of the, I'm not a strong proponent of the institution of marriage, but in a society where that institution exists and there are obligations that follow from it. Like, why should a woman be saddled with responsibility? And so, and given the societal realities where a woman is, for example, she moves to her husband's place. So we have a patrilocal society. She gives up her job maybe at the time of marriage. And how should it be so easy then for a man to just walk out of the marriage?
Yeah. And so many, now the care economy debate has also brought out this issue. And several judgments of Madras High Court and Supreme Courts, they are also bringing this argument. Thank you very much. It was very, very enriching discussion. Both of you made it so rich with the case studies and experiences and even the logical argumentation. Yeah.
Thank you, Professor Patel and Advocate Almeida. Now I would like to invite our third expert for today's session, Advocate Mrunalini Deshmukh. Advocate Deshmukh is renowned lawyer and author, Mumbai. Ma'am's topic is conjugal rights of women with special emphasis on property, inheritance, and alimony. Very warm welcome to you, ma'am, and over to you.
Good afternoon. It's Merry Christmas, season's greetings to all of you. Am I audible? Am I audible?
Yes,
Yeah.
ma'am.
Good afternoon.
So season's greetings to all the lovely women here. I'm singularly fortunate to be a part of this erudite group, which has taken upon itself the legal awareness to bring about what are the rights, what are the duties, what is the scope of the laws as far as women are concerned in different fields and in different sort of areas of law. I have been given this to talk about the conjugal rights in relationship with the maintenance, the alimony, the inheritance, and what are the rights that have been evolved over a period of time with reference to all these things. At the outset, we have to understand that when we talk about these laws, we have to see that the devolution of these laws is based in our history and in our culture. And that is very important because our laws of inheritance or personal laws, and I think the speaker before me, I just happened to log in and I did hear some part of it, was talking on the subject of Uniform Civil Code, whether it should be there or it should not be there. And the reason for the same is as under, that today we have personal laws which govern our lives. So personal laws which are Hindus, Muslims, Sikhs, Parsis, and so on and so forth. Now, when we talk about the personal laws, these personal laws find their basis. And I'm just taking the Hindu law as an example because most of us are governed by that. And so these laws find their basis in the Shastras and the Puranas and the Vedas. They are known as the Smritis and the Shrutis. From there, this law came down by the word of mouth, by custom, by practice. And thereafter, we had the codification of the act, which is the Hindu code, which took place. And then we see in the year 1955, 54, or 56, various laws were enacted. These laws were the Hindu Marriage Act 1955, Hindu Adoption and Maintenance Act of 1956, then Hindu Succession Act, and of course the Special Marriage Act and such other enactments that came into force. So the enactment and the codification brought about a legal structure and a format to them, to the enactment to give it a particular direction. Now, in this background, we have to understand what were the rights of the women prior to the codification and prior to these laws which came. Did women have rights to own properties? Did women have rights to give in inheritance, as it whether it could devolve by succession to their children or to whomsoever they wanted to do? And could women be said to be, in the real sense of the word, the owner of the property to deal with it in a manner that they feel appropriate, which today you and I can safely say we can do about it, thanks to the law, which has strengthened us and sort of given us those provisions to be able to hold that. Initially, I mean, as I think all the speakers may have said, I was not a party to it, but I'm sure most of the speakers have said that we belong to a patriarchal society, undoubtedly. And our origin is in the patriarchal, not only society, but also the mindset. And that mindset reflected in those days in the customs and the traditions that followed. Today, law was needed to bring about the revolutionary change, and which law has brought about. So earlier, the right of, or the concept of money, finances, properties were alien to a woman. The right to a woman was only that she could be maintained or taken care of. Now that maintenance could come from her parents, from her father prior to marriage. Post her marriage, it was her husband, and God forbid the husband died or she was a widow, it was the son who was supposed to take care of the woman. So it was a dependency that the woman had on the male, whether it was the father, the husband, or the son, on which her survival, her existence was dependent. So under such circumstances, expecting that the society and the law at that point of time would give her the rights to own the property is something unheard of. So obviously, as it progressed, as law progressed, the Government of India Act came in 1935, where certain provisions were made, which was towards the path of, after we got the freedom, the Constitution. In fact, some of the provisions in the Constitution find their basis in the Government of India Act of 1935. There was a movement that went on. And the movement that went on was not only from the legal standpoint and from the rights part of it, but the movement that went on was to bring about an equality and gender justice as far as the social structure of the country was concerned. So we had very social reformers who did that, who brought about this. We had to eradicate the customs of sati, etc., to be able to give that woman that status and the honor in the society. So the first law that came into force as far as the property was concerned was in 1937, the Women's Right to Property Act of 1937, where they gave a right to the woman to be able to hold property. But again, that act had its own limitation, where it could be only during the lifetime of the lady. So she could only use, enjoy, or deal with it during her lifetime. She did not have any rights to deal with it post her death. So this is just a little background, which is not so important for our discussion, but I'm showing you the flow that it has come out. And that is where, after the codification happened in the year 1950s, and there was a lot of debate that took place in the assemblies, and it took place in the parliament at that point of time, then why should there be a Hindu code? Dr. Ambedkar was, in a way, had his own views about it. And there were a lot of legal thinkers, social thinkers who thought about it, that what was the reason for the codification of the Hindu code and how it was necessary and how did it strengthen the human beings or the people governed by it in a better manner. So for the first time in 1955, when the Hindu Marriage Act came into force, there was an act under which parties could get married. So the conjugal relationship between a man and a woman found its basis or its origin in the Hindu Marriage Act, where the husband and the wife, they got married. That relationship gave them the rights to be living together as partners for procreation and so on and so forth. So when the marriage took place after that, the question that arose is that arising from the marriage, what are the rights that a woman has? Let's say A got married to B. They had a very happy hunky-dory marriage. Everything went off well. The wife was taken care of, and she unfortunately died in her own natural way. And things were okay. There was no need for her to be worried about any of these things. What happens if the woman is shortchanged in the marriage? What happens if the woman is not given her due in the marriage? What happens if the woman is subjected to violence in the marriage? But does she have a recourse, or does she have no recourse? And because she has no maintenance, or she has no sustenance, or she has no money to fend herself, she needs to stay in the marriage itself. So that was where the act came into force, and that act gave her the clause, or I would say the teeth rather, which probably in some cases have been used as clause, and I'm going to make a very, very practical statement about it as we proceed, which gave her the teeth to get into it, to be able to maintain herself, to be able to go to the court of law to seek her dignity, which also meant a financial dignity. And that is how the law of maintenance came into it. Hindu Marriage Act talks about 2 sections. Number 1 is section 24, which is an interim maintenance that has to be awarded in a particular case to a woman. And what are the parameters for that? Section 25 of the Hindu Marriage Act talks about the alimony that has to be awarded to the wife in the case of a separation. I don't know how many of you know, but the Hindu Marriage Act is one of the finest acts of gender equality and gender justice, because it applies equally to the man and the woman. When I say that, if in a given situation there is a man who is unable to maintain himself, the husband can also go under section 24 of the Hindu Marriage Act and ask for maintenance from his wife if he's unable to maintain himself, and if the wife is earning and she has sufficient income of her own. Similarly, in the event of a divorce, whether he goes for a divorce or the wife goes for a divorce, and the courts find that the husband has no money and it is the wife who has got sufficient money and the husband needs to be maintained, sorry, he could go to the court of law, and the courts, after considering all the facts and circumstances of the case, could do that. But which is not so, just to make a parallel with the Special Marriage Act, because the Special Marriage Act deals exclusively where the wife is entitled to ask for alimony or maintenance. So the right of maintenance that took place, that found its origin under the Hindu Marriage Act. Later on, it could not be a situation where a woman had to go only for maintenance if she wanted to go for a divorce. Was there any other provision that was made under the enactment to enable a woman to knock the doors of the court in the event she was not maintained or she was not taken care of by her husband and the family members who are supposed to do that? And if that is so, does it mean that she has to file for divorce? As my earlier speaker spoke about it, that it's not always very convenient and it's not always very desirable for every woman to go for a divorce in the social strata or the social structure that we are talking about. And let's not talk about the year 2022, 2023 as we walk into that year. But we are talking about it at the time when the enactment was made, the social structure was there. Please understand one thing, that all these laws of maintenance that came forward, that came after the Hindu Marriage Act and the other enactments, were based on the fundamental rights that were enshrined in the Constitution. Now, I'm sure all of us here, I mean, the audiences is extremely erudite and well-read, but just to give a perspective to what I'm saying, Article 14 of the Constitution talks equality before law. Article 15 of the Constitution also says that there shall be no discrimination between any two persons, which is based on caste, race, sex, religion, color, etc. Now, do we know that Article 15, subclause 3, where in the heading it says that there shall be no discrimination between the two sexes, between two people based on caste, religion, sex, etc., has a section which says that nothing shall prevent the state means the country, or the state in the sense of the country. Nothing shall prevent the state from making any special laws for the women and children. Now, it becomes quite of an anomaly to understand that when on one hand you're talking about there should be no discrimination, then why is it that in the same section, subclause 3 talks about nothing shall prevent the state from making special laws for women and the children? And the reason for that was only because of the social structure that existed at the time when the Constitution and the fundamental rights were there. We have to understand, as somebody said earlier, equality is between the equals. You cannot have equality between the unequals. So the social structure at the time when the Constitution was drafted was the man, because the patriarchal society, the way the Indian society was there at that point of time, that the man was here and the woman was here. Now, can we talk about an equality when this is the difference between the man and the woman? So what did the constitution makers and the fundamental constitution makers think about it? To give the fundamental rights to the state, to empower the women, to be able to rise to that occasion, to rise to that level where, if not equal, they could be somewhere equal to them. And then the equality would step in. If equality and equal protection has to have a real effective meaning, not something which is written, is a word on paper, which has no reality or which has no real consequences in real life. And that is why the section, clause 3 was added. And that is how it gave the state, that is the legislation, to enact several laws in favor of the women, to empower them, to protect them, and also to be able to be really equal in the eyes of law, in the sense that it had, the framers of the Constitution had envisaged. So coming back to this issue of the maintenance that I was talking about, when we had maintenance under 24 and 25, there could be a provision where a woman doesn't want to get divorced, and at the same time she wants to live separately, because say my husband is a drunkard, or say my husband is a womanizer, or my husband beats me up, doesn't give me money, ill treats me, kicks me, whatever, etc. Am I supposed to live there? But I don't want to leave him. I mean, why should I give him a divorce and just give him everything on a platter, is what probably the thought was. Am I allowed to be away from the marriage? And if I'm away from the marriage, and if I have no money of my own, and if I have to fend for myself and I'm unable to do so, will the law say, too bad, you've left your husband, now you're on your own, you try and do what you want to do, beg, borrow, steal, work hard, make money? No. So that is why the Hindu Adoption Maintenance Act came into force. It was in the year 1956, wherein the Act section 18 talks about where a woman, under circumstances, and those circumstances have been mentioned under the enactment, where under circumstances is well within her rights to live away from her husband without forfeiting her rights of maintenance and without forfeiting her rights of what a decent, dignified living is. So the law said that if you, woman, if you are trapped in such a situation that I've just mentioned earlier, it doesn't mean that you sit and suffer. It doesn't mean that you sit and blame your ill luck and say, oh, this is what my destiny is, I'm supposed to be, I better stick on here. The law is there to empower you. The law is there. And that is why the 56 Act came into it, that if under such circumstances where there's cruelty, there is alcoholism, there is abandonment by the husband, etc., the woman can live separately without forfeiting her laws, her rights of maintenance. And rights of maintenance, what are they? What could be the possible, the combination as to how much are you entitled to, how much is the other spouse entitled to give you, are all the parameters which are there in section 23 of the Hindu Adoption Maintenance Act. So the applicant has to make reasonable claims. The husband has to make a reasonable offer. The courts are going to see the number of dependents of the husband. Suppose if the husband is earning 100 rupees and the number of dependents on him, can the wife say, okay, I'm staying separately, you give me 50 rupees. The law says no. We will have to ensure what is the income of the husband, what are his responsibilities and liabilities, besides that being that for husband. So there are children concerned, then he has to take care of the children. Then that has to be taken into consideration. There are old parents who are at times living with the husband, and he has to take care of them. So the number of dependents which are there is also one of the factors that the courts considered at the time when they award maintenance to a woman who knocks the door for these particular rights under the Hindu Adoption and Maintenance Act. The another act that came into existence, it was always there, was the Criminal Procedure Code, which has section 125. And section 125 of the Criminal Procedure Code also talked about maintenance to be given to the wife, and what are the facts and circumstances, and what are the criteria. What happens if there is a change of circumstances? Can there be an alteration in the allowance, either more or less? Change of circumstances can also mean that you can go back to the courts and say, okay, you granted me 100 rupees. Now the situation is different, blah, blah, blah. And it is not possible for me. Inflation has gone up multifold. I have child, I have other responsibilities. Kindly enhance that from 100 rupees to 150. Or even if the case may be that she requires anything else. The husband as a respondent could also go and say, okay, but the court granted 100 rupees to this wife. At that point of time, I was earning, and that was a justifiable number that the court gave. I never made anything. Today I've lost my job, or today I have become incapacitated due to XYZ. I have no income, and I cannot be expected to comply with the orders of the court. The courts will also consider that. So 125 Criminal Procedure Code was an enactment where the aggrieved woman could go to the court of law and she could ask for maintenance for herself. Now, fortunately for some of the women who are in such situation, 125, a woman who is also a divorced woman can go under that enactment asking for maintenance, though she is not classically a wife. A wife is someone whose marriage is in subsistence. But this provision also talks about a woman whose marriage has been dissolved. And such women also have a right to go under the same thing. Now, I'm sure many of us know about the absolutely landmark and the historic judgment of the Shah Banu case of 1975 Supreme Court, where the then Chief Justice Justice Y.V. Chandrachud, who is the father of the present Chief Justice of India, gave that judgment where even after the divorce, under the Muslim law, the Sharia law, which entails that the wife is only entitled for the meher amount, because as we all know, Muslim marriages are a contract, and a contract is a contract which is based on consideration. Because there's no consideration, that contract is not a valid contract. So that consideration is the meher. And the Sharia law said that only the meher and the iddat, that is a reasonable maintenance for a period of 3 months, is all that the wife was entitled for. And she was not entitled for anything else. And that's the time when the courts came to the rescue of this old lady, 70-year-old lady, Shah Banu, who was truly an activist and a crusader for the atrocities that were perpetrated on the Muslim women by either the male counterparts or the law that they were governed by, and were at the helpless and the help. So that is where the new law came in, which is protection of divorced women under the Muslim law. What are their rights? Their rights now included not only the meher and the iddat amount, but also the phrase that is used in the enactment is a fair and a reasonable provision to her. Now, fair and reasonable provision for the wife may include various factors. It may include not only money for her survival, it may include money for if she, God forbid, she has any medical health or health issues, so extra allowances for that, or in some cases even for the residents. If the parties belong to a very high standard or an affluent standard, then there could be house that could be sought, or at least rent, which could come under the fair and reasonable provision of law. So the enactment which came into the year 1986, I'm sorry, this was the 1985 judgment. I made a mistake, I said 75. It was 1985 judgment. This act came into force in 1986, where the women, divorced women, were protected under this by the enactment that was brought about by the legislation. So I'm trying to say that there has been a lot of progress and a lot of emboldening for the women and giving them the rights by the legislation and the judicial activism. As we all know that laws are laid by the legislation and the judiciary is only there to interpret the law. But at times, and many a times, we have seen, like we've seen the case of Shaira Banu, triple talaq. We have seen in many other cases also, this 1985 case was also a case where the courts came to the rescue of the woman, the old Muslim woman who was left to the vagaries of the nature and who was bound, as they say, by what the Sharia law said as far as the divorce and her financial rights are concerned. And that is when, because of the observations of the court in that order, the new enactment came, which gave her the option of going back to the courts if she's not provided for, and going and seeking fair and reasonable provision. As we progress, and I know time is running short, and I was told I have to speak for 20 minutes, and I won't take much of time because this subject and this topic is endless. And I can tell you, I mean, there are so many nuances, there are so many factors, and there are so many sort of examples that one can give. But if I have to be very concise and sort of, in my presentation here so that I cover a lot more topics rather than dwell on one of them. The other important point that I really want to bring about this is So we've discussed about what is known as the Section 125 CRPC. We have discussed, or rather I've mentioned about the Hindu Marriage Act, which had Section 24 for interim maintenance, and Section 25, which was for alimony, and the final sort of, things consequential, or as they call it, the aftermath of the divorce, whatever her rights are there, ancillary rights is concerned. That is number 2. We spoke about how under the Muslim law, the Protection of Divorced Women Act of 1986 came into existence after the historic judgment in 1985. Now there's a new concept that also came in. All these things that we were talking about, please understand one thing, revolved around the concept, and that is why I thought this is very important for us to understand, revolved around the concept that there is a marriage and the rights that accrue from a marital relationship between a man and a woman. But as society progressed and as the social structure changed, and as women became more independent and women had a say in everything and so on and so forth, the concept of two people having a live-in relationship came into existence. And these two people, the man and the woman, thought of not getting married, but living as partners. I don't know how many of you are aware of, but in UK, there is what is known as a partnership agreement that is entered into between the man and the woman. So which is not a marriage, but which is a partnership agreement, where the man and the woman under the agreement decide that they will be living as partners. And they have an agreement which talks about what happens, who contributes what to the house, I mean, who runs the house, and if there are kids that are born from the marriage, what is the provision for the kids, who even simple things like who does the dishes and who does the cooking and who drops the kids to school and so on and so forth. But of course, this is in a lighter way. But many of these provisions are put into this partnership agreement. And in the event of a dissolution of that, there is absolutely a dissolution of the agreement or a contract, as it happens in any other commercial transaction that we have. Now, many times in many of these how do I say, interaction with people like the way I'm having today, where I don't like to say that I am giving lectures, but where I interact with people like you, the question that is often asked, does the change in society bring about a change in law? Or does the change in law bring about a change in the society? Just a moment. And for me, as a student of law, I have very little to say on it, because I think both complement each other and bring about, or they have a counter effect on each other. So as I was talking about it, there was a concept that was slowly started growing. And that concept was of a live-in relationship. So there was a man and a woman who lived together, who literally performed all the I would say, rights and the duties of that of a husband and wife, but did not have the legal status of the husband and wife because they chose not to have it. Now, when everything is fine, hunky-dory, obviously they don't need lawyers, they don't need courts, they don't need laws, because it's only love that sort of, guides them and takes them through. What happens if the marriage is, this relationship goes south? What happens if there is a fight? What happens if there is violence in this kind of a relationship? What happens if there is violence which is not only of a physical nature, where there is a physical abuse or battery or something, but which is also in a nature where the woman is not provided for? But does that woman become helpless, hapless? Law has not made provision for her so that she cannot go to any court because you are not the wife. Now, these are the questions that started coming up. I remember when I started practice, I'm talking about people coming from really middle class and lower middle class, where a man would get married to a woman and the woman would have a child of etc. from their own. Then the man would stray and we would get into a relationship with another woman, either to the knowledge of the first wife or not to the knowledge of the first wife, so-called get married to her, have children or not have children. And then when there is a dispute that would come up, what would be the rights of that second wife? Because there's no concept of second wife under the Indian law. Indian law talks about monogamy. Monogamy is one man, one woman relationship. So what happens to that second wife, if I may use that word for ease of understanding? That what is the right? I remember as a young lawyer, when I was going to courts, that these women, when they came, the courts would say, sorry, I don't think we can provide anything for you, because I agree, you have shown me some temple marriage that has taken place. I agree, you've shown me some ration card in which your name is there with that of his, and so on and so, to show proof of marriage. But there is no marriage that has taken place. And if there is no marriage that has taken place, there is no concept of a second wife in law. And the law is only for the first, or for the wife who's a legitimate wife. So these women were really, and I've seen that in front of my eyes, where the judges were sympathetic, had empathy for such women, but were not able to provide anything because the law did not provide anything. So giving you this example, the concept or the evolution of a live-in relationship that became very rampant. And I don't know whether it is there in the tier 2, tier 3 cities, but basically it started with these in the urban metro cities, where two people decided, who fell in love, decided to have a live-in relationship and try out that relationship and see that. What were the rights of such women? I'll just sort of go a little away from what I'm talking, and I'm going to give you an example, which has nothing to do with what I'm talking about, but just to see how the social structure is. This was 4 years back that there was a couple who came to me. The boy was 35, the girl was around 32, 33, but they looked much younger than what their age was. And came from an extremely well-to-do, erudite, highly educated, financially fiercely independent, so nobody was dependent on that. And they came to me. So I asked them, yeah, what is the problem? And how did they go? So they said, we want a divorce. So I said, when did you get married? So they said, we got married 3 months back. I said, oh, y'all didn't know about each other? So what shocked me was when they said, no, ma'am, we were in a live-in relationship for 10 years. 10 years. So which means when they were babies, when they were 23, 24, if I may say, I'm not exactly very sure about the age, but when they were 22, 23, at that age, they started living together. And after they lived together, they said after 10 years, we thought about it, that I think it's a good time for us to get married. They didn't have any children in that. And some of them were studying, some of them were working and doing that. And as I said, they did not need any maintenance or something. And then they got married, and within 3 to 4 months, they came to me for divorce. I asked him a very simple question. What is it that changed in the 4 months, where the last 10 years further gave you confidence that your your relationship was meant to be, in that sense, illegal by getting a marriage? He said, we have no idea. I said, how can a certificate or a document determine that you are happy or unhappy? How did it happen? He said, we have no idea. And I also have no idea. So this is one example that I'm giving you, which has happened in some of these live-in relationships also. So coming back to the issue that I was talking about, the live-in relationship, in this side of contention, what is the law with regards to a woman who is shortchanged, or who is subjected to domestic violence, or who is subjected to any kind of torture or harassment? What is her remedy? Or is she remediless because she does not have the status of a wife? Which is where, after a long time in the year 2005, the Protection of Women from the Domestic Violence Act came into force. And this, for the first time, recognized a relationship which is not of the woman, which is not necessarily in the natural format of a husband-wife structure, but who could be in a live-in relationship, as we normally call, or a relationship which is similar to that of a marriage. And she could also knock the doors of the court and ask for maintenance, ask for, if there's a child born from that live-in relationship, ask for any of the reliefs that any other mother would, in a legitimate marriage and relationship, could ask for. And those reliefs are basically monetary in nature, protection in nature, protecting her in that nature, and sometimes compensation if the courts find that there have been violence perpetrated on her, and it has to be compensated to the woman in terms of money. Now, most people have a concept that the Domestic Violence Act is a criminal act. So the word talks about Domestic Violence Act, but it is not a criminal. The act is criminal. I mean, violence is criminal, is what I'm saying. But it does not come under criminal law. It comes under the civil law, with a provision that the woman could even approach the first-class magistrate or the metropolitan magistrate wherever she's living and seek the similar relief. There is section 26 of the Act which says that she could also file these proceedings in a family court or a civil court if there are any other proceedings. The idea being to not make her run from pillar to post, which happened. How good am I on the time? Sorry.
I think you have time. Don't worry. Today, yours is the last one. Hello.
Okay.
We can exceed. Yesterday also we exceeded by half an hour because it's a very committed participants we have. But I would also like you to throw light on inheritance and law on inheritance.
I will.
Nobody has in the previous 9 lectures, it has not been taken.
Okay. I'll just take another 5-10 minutes before we get into it. Because I'll tell you why I'm doing this more than inheritance. Because these are the kind of things that we are facing in court every day. And these are the nuances and the variety of law that we are, sort of getting into. So I'll just wrap this up. As far as the compensation under the Domestic Violence Act for the woman was concerned, there was a lot of cases that came right up to the High Court, right up to the Supreme Court. What happens? Does a live-in, sort of giving recognition to a live-in relationship, does it mean giving permission for adultery? Was a question that was asked. Today, I'm unhappy with a man. I go and have a live-in relationship with a man. I'm still a married woman, but I have a relationship with a man. Is the law saying that you can have adulterous relationship? Is that what they're saying? So these are the kind of cases that came up before the Supreme Court. And there were various cases that came up before the Supreme Court. And there, I've got a detailed note, but I won't get into it, where the courts came to the conclusion that only that live-in relationship would be considered to be a valid live-in relationship, which, if the parties chose to get married, could have got married. So that was the sanctity that was given to the live-in relationship, which was there. Now, coming to the inheritance part of it, as I said, the right to property had a restricted and limited role prior to the enactment and prior to the codification. Post the codification, the law gave a lot of rights to the women. And one of the examples that I would like to suggest is that we have the amendment of the Hindu Succession Act, which took place in the year 2005. And that act brought about a major change. And I'm happy to say it was Maharashtra who started with that, amendment, and that later became the movement, and that later became the act. Where, as we know, the social structure, and again, I'm sorry, but I go back again and again to the social structure because that's where the origin is. Because the social structure, as far as the co-partnership properties were concerned, it was a highly male-dominated one. Only the males could be the co-partners, only the males could inherit. The 1956 Act did give rights to the woman under the enactment to be able to devolve her property, what a class 1 is, and so on and so forth. But the major amendment that was brought about by the 2005 amendment was that a woman or a girl child, if I may say so, on her birth became a co-partner or became a member of the joint family or the undivided family of the Hindus where the parties were concerned. And she had the same rights that her male counterpart had prior to the year 2005. As a result of which, but this was not a retrospective one, it was obviously a prospective one coming from the year 2005 onwards. But by doing such a thing today, the rights of a woman are not only there by way of her self-acquired property, because we all know that property is divided into self-acquired, gifted, or inherited. So today, the women are not only fortunate enough to have the self-acquired property or maybe gifted property from their family, but today by birth in a family, they have a right of having the inheritance because they are part and parcel of the joint family property, and equal partners and equal partnership or equal shareholding, if I may use a commercial word, is what they have in that kind of the laws which are available. The second fight that we're talking about the property, and the reason I'm using the word fight is there is no clarity in law on that. Overseas, there is a concept of marital properties and marital assets. What is the right of a woman in the marital assets? What are marital assets? Marital assets are those assets that are acquired by the husband singly, by the wife singly, or by the wife and the husband jointly during the course of their marriage. What is the right of a woman in that? But there is no certainty in that area as far as the law is concerned. We do not have the concept of the equitable, proportionate right of the parties in the marital asset. Today, the rights of a woman in the marital assets is only limited to alimony and to a residence, depending on what the standard of the parties is concerned. So this is something that needs to be looked into. Overseas, now, for example, if you see on the West Coast in the US, it is a very, very clear demarcation. You got married on 1st Jan 2020 and you got divorced after 5 years. During that period, what are the assets that you have done? It also includes debts and liabilities. Of course, it's not only, it's a net one. What are the assets that you have acquired? What are the debts and liabilities? That has to be equally divided so that there is, because there is equal contribution in the marriage. So why should whatever be the fruits of that be only going to one, which is what happening in this case? Now, I'll tell you one other thing that happens, and I think it's a very practical question. A husband and a wife, they buy properties. The property is completely funded by the husband, and the wife's name is added as a co-owner. Now, what is her role as a co-owner? What is her right as a co-owner? And tomorrow, God forbid, when the matters go to a court of law and nothing that really sort of the marriage doesn't survive, how is her role defined? Today, I can tell you, ma'am, there is still a lot of gray area as far as that is concerned. I can't say because my name is on that property, I'm the 50% owner. It's a 10 crore property, I'm the 5%. No, the courts will go under the Transfer of Property Act. They will consider what is a situation where, but at the same time, I must tell you that there are cases where husband's wife buy properties in the name of the wife. For whatever reason, it may be for security, it may be for taxation purposes, it may be for distribution of the things there. And if the matters go south and there's a division that happens, he cannot recover the property from the wife by saying that I have contributed, you have not contributed a penny to it. So it doesn't work this way. So there is, law is evolving. There's a lot of gray area as far as the property rights of the women are concerned, especially coming to the marriage part. And inheritance, I've said that these are the things which normally are now sort of, emboldened and strengthen the hands of the court, of the women to sort of seek their rights. I think I've tried to cover.
Do these laws touch the LGBTQIA plus community?
Right now, no, because right now there's no legal recognition in that sense of the word, because it is presumed to be a man and a woman. So unless we have same-sex marriages which are allowed, unless we have those. So today, I think where we have only made a progress is to decriminalize it, as I understand. See, socially, we may have made a lot of progress with people like us who think very positively about it, and we recognize their rights, and we recognize their existence, their rights, everything should be there. What is wrong with that? That's their way of orientation, not ours. But the law today still talks about a man and a woman as a husband and wife when we talk about it, and as far as the properties are concerned in the matrimonial properties.
Thank you, Advocate Deshmukh, for an insightful session and giving us significant information. I would like Professor Patel to comment on what Advocate Deshmukh said.
Yeah, I think Advocate Deshmukh she has been such a veteran in this field and working both at a petition level and at the courts, various courts that she has taken up the cases. So I think her wisdom and the way balanced view that she has provided about all the laws regarding maintenance, alimony, and inheritance, I think they are very useful. And I think the humility with which she is that there is nothing in affirmation. Things are still evolving, and social structures are very important to it was the 30 years of women's movement where individual women who challenged the discriminatory and unjust aspect of family laws, starting from Mary Roy challenging Syrian Christian personal law, Shahnaz Sheikh challenging Sharia law, Parsi ladies challenging her marriage to the social boycott as a weapon used by Parsi Panchayat, and she won the case in 2017. So it's a very long battle. So individual women's struggle resulted in bringing so many legal reforms. So I think the one lesson that we get from her lecture is that we need to continuously critically reflect on what is happening. Indian judicial system is responding to the collective wisdom of the masses. And I think the legal awareness, legal activism are extremely important. And I think all three speakers today, Saumya Uma, Albertina, and Advocate Mrinalini Deshmukh, I think they have complemented each other by giving this thing. But one thing is that even when Advocate Mrinalini said that Hindu law is the most progressive, but still, I think I would agree with Albertina where she said that all of them are equally discriminatory, because when it comes to any family laws, on 7 counts, they have double standards. Whether it's a marriage, divorce, custody of child, alimony, right to matrimonial home, right to parental home, land rights of rural women, or the double standards of sexual morality for men and women that we are facing. And also recently only the law on adultery, which generally treats wife as a property of a husband, I think that has been challenged. So I think we have a long way to go. And I think and now even in the context of India taking presidency of G20 and India being inducted in the ECOSOC of the United Nations, I think a lot of global pressure is also coming. We have a mind-boggling issue of NRI marriages. Currently in the Home Ministry, there are 12,000 cases of women whose parents have been completely devastated. They themselves are devastated because after going to the new destination, these women have been betrayed, they have faced domestic violence, they are robbed of their passport. So I think our law will not, it will also have to transcend the border, the nationality border, and we'll have to come up with a global law, because the cross-country marriages are also increasing. So that is again a gray area. I think there are so many gray areas that we have. So I think we need to critically examine these issues. And all 10 lectures which focused on the reproductive rights of women and the conjugal rights of women, I think, and how closely they are linked up. I think that's very important. So we need to understand the political economy and the material reality in which women are there. We need to have intersectional perspective of the vulnerabilities created as a result of caste, class, race, religion, ethnicity, even the barrier of language, because most of the legal luminaries are having discourse in English. And how do you see a housewife who speaks the local language to express herself in the legal court? Most of the women's rights organizations, that's what we are doing. We are doing the hand-holding of the women who are aggrieved party, and the whole power balance and the gender balance is totally against them. So this kind of program and this kind of immersive course that IMPRI has organized has made this issue, it has brought the issue center stage. And because these lectures are they are relayed in 6 platforms. So I think, and they are also used by several universities, colleges, and the NGOs for their legal awareness and legal education. So I think it is going to have a snowballing impact. So with this, I would like to thank once again the IMPRI team, Naina Agarwal, Satyam Tripathi, Fiza Mahajan, and of course, Dr. Arjun Kumar and Dr. Simi Mehta, who initiated the process. Over to IMPRI team. There is an opinion poll. Okay, yeah.
Thank you, Professor Patel, for the concluding remarks. As we have come to the last day of a 3-day immersive online legal awareness and certificate training program on reproductive and conjugal rights of women in India, I, Naina Agarwal, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI Gender Impact Studies Center, GISC, New Delhi. We are grateful to our expert for the last day of this online certificate training program, Professor Dr. Saumya Uma, Advocate Dr. Albertina Almeida, Dr. Amar J. Sani, Advocate Dr. Shalu Nigam, Professor Vijay Lakshmi Nanda, Professor Veena Vaswani, Professor Mala Ramanathan, Advocate Audrey D. Mello, and Advocate Mrunalini Deshmukh, and to Professor Vibhuti Patel for chairing the session. We thank all our participants who have raised pertinent questions and actively participated in today's celebration. This is to notify the participants that we do not share the experts PPT as an institute's policy. Those who need a copy of it can write and get in touch with the experts and request the same citing reference to this course. We will share the feedback form by email. Kindly fill it, following which we will share the certificate of completion in a couple of days. We have shared the recorded videos of the training program in your email for your kind perusal in case you have missed the live sessions. Thank you to the organizing team, IMPRI, Gender Studies, New Delhi, for conducting the whole session in smooth manner. We are grateful if you are watching us later on YouTube or listening to us on our various podcasts or reading our publication. We hope you continue to join in for our IMPRI Web Policy Talk and Web Policy Learning. Wishing you a good day and thank you.
The question, this response can also be given in the chat box, no? It's there. Hello.
Yes, yes, ma'am. We will share an email.
But it's also there, no?
Yes, yes.
It is there in the chat box also. Yeah.
Yes, yes.
Yeah.
Thank you. Thank you, everyone.